One of those, obviously, is the antagonistic defenses. Are you joining their position that you don't anticipate that being a consideration here?
I don't think that there's antagonistic defenses because, as my
firstly, we will contend that a trial of these 19 co-defendants will take 4 months, and that does not include jury selection. And it's also predicated upon whether or not, of course, the defendants elect to testify or not. But 4 months is our time estimate. In terms of the number of witnesses, there are in excess of 150 witnesses that the state intends to call. 150 witnesses.
On Collins versus the state, 312 Georgia 727. 3 factors to consider are the likelihood of confusion of the evidence in law. I think the state's made that clear, so I just want to make sure that that's cleared up for the record. There's some statement. And just before we depart, we would just ask for.
I don't think we can take for granted that these would both be 2 equally 4-month-long trials. I think it could easily be twice that with multiple defendants, and I think we need to take into account the fact that one docket goes entirely on hold while this case is going, and instead of it being, if we're purely considering aspects of judicial economy, which to me was really the only valid argument here, I think taking up 2 dockets and for a period of 4 months also weighs into that, as well as the voir dire process and the inconvenience to the jurors. So based on what's been presented today, I'm not finding that severance from Mr. Chesebro or Powell is necessary to achieve a fair determination of the guilt or innocence for either defendant in this case. And so I'll deny Mr. Chesebro's motions to sever from Ms. Powell. I'll deny in part Ms. Powell's motion to sever from Mr. Chesebro. And the plan will be to enter a scheduling order for Ms. Powell mirroring that of Mr. Chesebro with the October 23rd date holding. It sounds like the state is still sticking to the position that all these defendants should remain, and they want to address some of these removal issues. I'm willing to hear that. I remain very skeptical, but we can. I'm willing to hear what you have to say on it. And so, but again, because we're on a limited time frame, I don't think we have the luxury of waiting. So how long do you think the state needs to respond to that issue?
10 days?
Well, I think the 10-day mark from today. I know, again, I'm setting the indicator that folks are going to have more than 10 days to file their standard post-arraignment motions. Let's see if we can have that by Tuesday of next week. Again, this is limited to how you think logistically we could possibly keep these defendants together, and I think we can limit that to 10 pages.